Parents feel that with respect to their children, they know best. They believe they alone should be the decision makers relative to health, education, discipline, social life, anything related to the child's general welfare. Because children, due to their youth and immaturity, should not make decisions that would be against their best interests, and because parents have custody, the state should not intervene in the private realm of family life. Alas, this is not always the case, and an Old English doctrine is responsible for allowing the state to intervene in certain situations. Parens patriae is actually an Old Latin term used in the chancery courts in England to give the judges the power to act as a parent would, making orders for the protection and welfare of children. This term became the basis for the first juvenile court in the United States in 1899 and still is the law today. States have the power and the duty to interfere in family life when it appears that parents cannot or will not act in the best interest of their children. In Massachusetts, the operative terms are abuse and neglect. And if the state believes parents are abusing or neglecting their children, the state will intervene. The Department of Social Services in Massachusetts, a state agency, has drafted its own regulations with two purposes: to protect children, but also to respect the family's right to be free from unwarranted state intrusion. Abuse is defined in these regulations as the non-accidental commission of an act by a caretaker upon a child under 18 which causes or creates a substantial risk of physical or emotional injury or constitutes a sexual offense or sexual contact. Physical injury can be anything as innocuous as a bruise. Emotional injury means an impairment or disorder of intellectual or psychological capacity, as evidenced by a reduction in the child's ability to function within a normal range of performance and behavior. Negligence means the deliberate or negligent failure by a caretaker to provide a child with minimally adequate food, clothing, shelter, medical care, supervision, emotional stability and growth, or other essential care. Now, how does the state know that you may have abused or neglected your child according to the meaning of these regulations, especially when, for the most part, families are left alone? Someone reports you, that's how. It might be a concerned neighbor or a relative. It might be someone called a mandated reporter. That is, it is their legal obligation to report you. Say your son's school teacher observes bruises on his arms, and he says he fell off his bicycle, but the teacher has reasonable cause to believe that you hit him. The teacher or the supervisor will call the department to report suspected abuse. The phone call is screened in. An example of a report being screened out is if, for example, someone other than a caretaker may have hit your son. That could be a criminal matter and referred instead to the police or prosecutor. After it is screened in, the department now has an obligation to investigate your family. The investigation will generally consist of a social worker coming to your house, going through it, meeting all the members of the family, and talking with other people such as school and medical personnel and neighbors and relatives. The term reasonable cause is frequently used to support decisions relative to your child. If the worker has reasonable cause to believe your child has been abused or neglected, then the report of abuse is supported. This means the department not only has a file on you, but your name now will appear in its central registry. After the first investigation that resulted in the decision to support the initial report of abuse, the department will do a more in-depth investigation of your family. This is called an assessment. It takes 45 days, and 10 days after that, the department drafts a service plan for your family. Because the department's mandate is to strengthen and encourage family life, the department will offer services and suggestions to you for the general welfare of you and your children. For example, if the department believes you drink too much and abuse and neglect your child as a result, one of the items on the plan may be to attend AA meetings. If you disagree with these department decisions, you have a right to administratively appeal them. You would have to convince a fair hearing officer there was no reasonable cause to support the report of abuse and that the worker incorrectly applied the department's regulations to your case. Suppose that your child did not fall off his bicycle, but you spanked him and you believe this was appropriate discipline and not abuse under these regulations. You could be successful in overturning the department's decision to support your family for abuse. A father by the name of Donald Cobble, who spanked his son, did just that. In 1999, the state's highest court, the Supreme Judicial Court, agreed with him that he merely exercised permissible physical discipline, and that the department's decision to support the report of abuse was not supported by substantial evidence on the administrative record, and the report was set aside. For that family, that meant relief from state intervention, but they had to go all the way to the state's highest court to get it. This summary explains the basic procedures for the reporting and investigation of child abuse and neglect in Massachusetts. Other states have similar agencies and regulations. If you live in another jurisdiction, even temporarily, you should check the laws regarding the reporting and investigation of child abuse and neglect. If you have children in your care, whether they are biological children or children you are responsible for, such as stepchildren or daycare.